I think it is clear to believe in the power of ideas.
Fresh thinking to the Manhattan Institute.
Very nice introduction. And I have been in all of those sectors, but I started when I was 12. Beautiful building. Thank you to all of you for coming out on this dreary day. We're thrilled to be here. As Jim mentioned, this year the U.S. Chamber Institute for Legal Reform celebrated our 10th anniversary. And while that milestone gave us an opportunity to look back at how far we've come in improving America's legal climate, it also allowed us to look ahead to see how far we've yet to go. As we demonstrate in the white paper we're releasing today, fixing our dysfunctional securities class action system is one area where the finish line remains a distant yet achievable goal. This report looks at the flaws in the system, building on the work of the 3 previous independent commissions that Jim spoke of, and combines it with an examination of the fraud and abuse endemic in the plaintiff's bar, and offers specific solutions to address both concerns. Simply put, America's securities class action system is broken, both in its design and in its application. The system poses a serious threat to the health of U.S. businesses, the prosperity of American families, and the strength of our nation's global competitiveness. If that weren't bad enough, it's also a system often subject to extortion and abuse, as we've recently seen in the indictments and jailing of some of America's most prominent securities plaintiffs' lawyers. Today, I'll take a few minutes, more than a few minutes, to lay out the nature of the problem, its impact on shareholders, the business community, and our economy overall. And then I'll outline very broadly some potential reforms that will help to improve the system. The theory behind securities class action lawsuits, protecting investors from abuse, has a laudable objective. Yet today, the system is out of control, logically flawed, and betrays the very people that it's designed to protect. Securities class action filings now represent about 1/2 of all federal class actions in the United States. And since 1996, 41% of all the companies listed on the 3 major exchanges have been named as defendants in cases. Last year, we saw the filings of new lawsuits increase 58% from 2006. And in the first half of this year, there's been a 60% increase compared to the first half of 2007. And there's a new development that should send shudders around the world. It seems that U.S. lawyers are no longer content with just suing American companies. In 2007, we witnessed a 73% increase in 1 year in filings against companies headquartered outside of the United States. Securities class actions are growing not only in number, but in size. Businesses in 2007 saw their market capitalization plummet by a combined $151 billion the day after they were sued. This figure is nearly double that of the year before. I want to point out that these enormous financial losses occur when lawsuits are filed, not when the lawsuits are concluded. This means that even when lawsuits lack merit, the target company faces a very stark choice. On the one hand, it could settle the case for millions or sometimes billions of dollars. On the other, it could fight it out in court, inevitably diverting the time and attention of management and racking up mammoth legal bills, all the while running the risk of incurring a potentially catastrophic judgment. Research conducted by Professor Anjan Thakur estimated that between 1995 and 2005, Securities class action litigation caused the destruction of nearly $25 billion of shareholder wealth.